Correct.
So, awesome.
Okay.
Well, thank you.
For those of you who don't know us, we are in the DOORS program through the AIC, and what we do is we underwrite insurance programs for local governments. We not only do counties, we do cities and towns, townships, volunteer fire departments, things like that. My primary duty is to go out and work with our local governments to try to deter loss. In other words, what we're trying to do is specifically under the liability, because we want to keep our counties, our cities and towns from being sued. And so I'm just going to pass along to you just a few things for you to think about. These are just kind of red flags that are thrown up that when I go in and look at the county's like handbook, their hiring practices, things like that. Some of the things that they put in, their handbooks, and some of their practices, their training or lack thereof, things like that. These are some of the things that I look at. These are common issues that I go in and look at to make sure that, and I'm going to take each one of these individually and talk about them, but these are very important from a risk management perspective. And as Kent and I said, I'm not a lawyer, so I'm not giving you legal advice. I'm just simply saying these are things that we see. So I'm going to give you a little advice, kind of how to, say you can write this down, say, well, I'm going to go back and follow up with this, and, maybe consult with my county attorney and talk about some of these things. Now, the question is, how can we be sued? Well, there's, as you probably know, a number of state and federal laws, statutory liability, where we can be sued as a public entity for failure to comply with these different laws. Specifically, Title VII of the Civil Rights Act of 1964. It's a federal statute. I'll talk about that more specifically, but these are, we've got all these different acronyms. ADA, the Americans with Disabilities Act. It was amended just a few years ago. Now it's called the Americans with Disabilities Act Amendments Act. And it's actually what it did, it broadened the definition of what a disability is. And then we have the FMLA, Family Medical Leave Act, and and I didn't even put nearly, only just put a few up there, but these are some things that we have to comply with. So we have to, be aware of those, have some knowledge of them. We need to actually also something I'll talk about a little later is we need to make sure that our public officials have some basic understanding and knowledge of these different laws, especially since the fact that we all know that county government is broken up, by elected offices, and we have so many different kingdoms, so to speak. So we have to make sure that everybody's kind of on the same page with these laws. And again, that's another reason why we have a handbook that everybody complies with. There's also, because we're the government, we also can violate the Constitution of the United States, in other words, the Bill of Rights. We see a lot of claims under a federal statute called 42 U.S. Code Section 1983. And basically, it's a vehicle for enforcing civil rights. So if we violate the civil rights of some third party, or it could be an employee, then we could be potentially liable. Now, under Section 1983, the individual person that violated the constitutional rights could be liable. Now, that doesn't mean they're not covered by insurance, but the only way the county can be brought in to a claim under Section 1983 is if there's some unconstitutional policy, custom, or practice. We see a lot of these in the jail setting, in the sheriff's department, but it could also be in the employment arena also. So we'll talk about that a little later. So those are some of the federal statutes, but there's also Indiana statutes. The Indiana Tort Claims Act, which you may be familiar with. It's a statute that's used to bring claims typically of negligence, other types of theories of liability against local governments. And it's kind of a unique statute because it has some immunity in it, so where local governments are immune from certain types of liability, but also it has an 180-day notice provision. If you remember the State Fair incident where we had the stage collapse, well, there was a big issue that came up because there's caps on damages under the Indiana Tort Claims Act. So the state of Indiana was only responsible for $5 million, which is the aggregate under the state tort caps, and it's only $700,000 per individual. So you have some protection under these different state laws. In the federal laws, there's not typically caps on damages, but it just depends on what law it is. So again, I'm not giving legal advice, but I'm just giving you the flavor of what we see out there. Now, Title VII is the big federal statute as far as harassment, discrimination in the workplace. And it's based on, what it basically does, it prohibits any kind of discrimination against anybody, an applicant, a current employee, anybody based upon race, color, religion, sex, or national origin. Now, when I go out and do a training, like with employees and with public officials, they say, "Oh, we're gonna talk about sexual harassment." Well, sexual harassment is only one part of it because we have various laws to protect these different protected areas. In other words, these are protected classes. So again, we have the race, color, religion, sex, and national origin. Now, Title VII applies. Sometimes there's limitations depending on how many employees you have on what law applies. But under Title VII, it does apply to state and local governments and employers with 15 or more employees. Now, in some cases, if we have an employer, now all counties would fall in that category, but if we have small public entities and might have a little town with 4 or 5 employees, they might fall underneath one of these categories, or the threshold. But nevertheless, Indiana law applies. Their laws apply to 6 if they have 6 or more employees. So just to give you a little idea. Now, under the Indiana Tort Claims Act, again, it's a 180-day notice provision. And in other words, if somebody wants to bring a claim against a local government, they have to do it within 180 days. If they don't do that, the claim can be barred. Under also the Tort Claims Act, there are certain immunities that can be applied. In other words, local government can be immune from liability, even though they may have been negligent, for example. So, but under the employment realm, we have wrongful retaliatory discharge. We can have claims of intentional tort, such as like battery, defamation or like infliction of emotional distress, but also negligent retention or hiring an employee. And then we also have the Indiana Constitution. So we have a lot of different laws here, but typically, they follow, in some cases, a lot of times, the federal laws. But I just want to make you aware. Again, I'm not a lawyer, not giving legal advice, but I want to make sure that we've got all these laws out here, and we have many different ways that an employee could sue us. So we've got to have some understanding of that, and it is very important that we're aware of what those laws are. And again, it's a matter of education. Make sure the people who are doing hiring understand these laws. Make sure that your employees understand what may or may not be appropriate conduct in the workplace. In other words, they know there's certain things that may be construed as against the county policy and or potentially against the law. Handbooks are very important. I know Kent talked about that. Kent, you know anybody it's good that we can get a hold of that can put a handbook together for us? I just thought you might have a recommendation. But anyway, Kent and I work together a lot. Kent's a great guy. We actually rely upon them to do some review of policy and procedures for us. And but anyway, it's just very important we have a good handbook, and it has to be updated. A lot of times we go in and do a pre-insure. In other words, we're looking at a county. They want to look at potentially a proposal from us. So I'll go in and just ask a few questions. And first of all, do you have an employee handbook? They said, yeah, we've got this. And they pull it off the shelf, blow the dust off of it, and here we go. It's 1993. Oh yeah. So what I'm saying is that we've got to keep those up to date. Very important that we keep our handbooks up to date with current law. I mean, things are ever evolving, ever changing. I work a lot with sheriff's departments on the law enforcement side, and they're developing their standard operating procedures, but it's just an ongoing thing because, again, things change and the law changes. Make sure that I know that Kent touched on this, does it properly reflect your practices? Okay, a lot of times you're borrowing handbooks from other public entities, and we'll just change a few things here and we'll make it work for us. But make sure that it does reflect your practices. It should be updated periodically, again, to reflect the law changes, employment laws and practices, and also enforced uniformly. In other words, we want to make sure, one of the points I want to get across today from a risk management perspective is make sure you're treating everybody the same. If you do that, you're going to go a long way towards avoiding potential liability. So make sure that, again, all your handbook, your different things in your handbook, they're enforced uniformly, and also an acknowledgement form. One of the things we talk a lot about in risk management is documentation. So I just want to make sure that you understand that documentation is very important from the standpoint of risk management, to manage that risk. If we get into litigation, one of the things we're going to come to you and ask for is your documentation concerning a termination or some disciplinary action. What happened in the past to cause you to terminate this individual? They're claiming they were the best employee that ever lived, but yet there might be documentation in file saying that they're not. But what if there's not documentation saying that? Then it's going to be difficult to defend that. So that's why the documentation is very important. So if you don't take anything else away from today, the documentation is very important. Again, we kind of start from the beginning. We're going to hire somebody. Again, an up-to-date job application. A lot of times we're asked to look at job applications. They may be out of date. They might have just got them off the internet or something like that. Make sure they're not asking inappropriate questions on there. Make sure that you have an up-to-date job description. Very important from a lot of different standpoints. Kent mentioned that several times in his presentation about referring back to that job description. Very important from the standpoint of defending claims, especially if you have somebody comes in and applies for a job and has a disability. Are we going to be able to accommodate that individual? What are the essential job functions? Can the employee or the applicant meet those essential job functions? So having that job description is very important. And I kind of get sometimes the same argument that Kent gets about that if we only specify these job duties, they don't have to do anything else. But you can, if it's properly written, it'll be just fine. Make sure if you're interviewing people, anybody that's interviewing people from the county, make sure they prepare interview questions that are based on the job description. And make sure also that you're asking the same questions of all applicants. In other words, you're not asking different questions. You can screen resumes or applications based upon the job description or the pre-established hiring criteria. And then make sure that once you're conducting these interviews, you're retaining some notes. You're jotting down some notes, answers to the questions, things like that, and retain those interview notes and any documentation. Again, you're going to hear me say that a lot, documentation. Also conduct some background checks, reference checks, things like that. I'm going to talk a little bit about that a little bit later. We have to be very careful about that these days, especially with the criminal background checks and things of that nature. Make sure that you're getting an authorized release from the applicant to do an actual background check. You're probably familiar with the Fair Labor or the Fair Credit Reporting Act. It does require, in some cases, that we get a separate written notice or an authorization before a report from a consumer reporting agency can be obtained. So there's a lot of things that go along with that. So if you're getting a consumer report, a credit report, a criminal history report, something like that, you want to make sure that you're in compliance with the Fair Credit Reporting Act. So you might want to look into that a little further, again, when you're doing background checks on employees. Make sure also that you're complying with state and federal law regarding the applicants' histories, regarding the right of applicants not to disclose certain parts of their criminal histories or on employment applications, because that's changed, and Indiana's changed its law in reference to what type of criminal histories you're able to get, and then what the applicant actually has to divulge to you. So that's something we have to be again.
What part of that law has changed?
Well, it actually, I'll just read it to you here. Hold on just a second. I can give you some documentation on that, but basically, it changes the different types of like infractions, things of that nature that can be that don't have to be involved. In other words, if you get a certain type of infraction or expunged from your record, you don't have to divulge that on your application. So I can give you some information on all the specifics, but it changed. I think it was Kent, was that in 2013? I think, but when that changed. So I have some documentation. If anybody wants further information on that, I'll give you my email address and we can look at that. So I'll see if I can find that here in my information. As a general rule, employment applications not directly or indirectly seek information about applicants' race, religion, age, sex, or national origin. And then also seeking information about an applicant's protected traits can be used as evidence of the employer's alleged discriminatory intent. So again, we just have to be careful about, again, what type of application questions are there. Again, go to if you have an HR professional or you want to have it legally reviewed, you can have that done. So just make sure you're asking or you're not asking inappropriate questions. The employer may not ask if an applicant has a disability or inquire as to the nature of or severity of any disability or medical status. So also age, dates of graduation, uniform service commitments, pregnancy, childbirth, or related medical conditions. So again, these are things that are prohibited to be asked on a job application or in an interview. So we have to be very careful about that. I think most people are probably familiar with what the at-will doctrine is. If you're not, basically what it is I'll just read it to you, but it's basically, as a general rule, the employment relationship is consensual between the employer and the employee. So absent specific exceptions, an employment relationship may be terminated either by the employee or the employer at any time for any reason or for no reason at all. So basically, most county employees, unless there's some type of exception to that, in other words, it could be like an employment contract, it could be an ordinance or a statute, it could actually also be in your employment manual. Unless it's in there, they're at will and can be terminated without cause. Now, an exception to that would probably be your merit sheriff's deputies. They typically have a right to their employment, so there's a certain statutory procedure they have to go through. So you'd have to make sure you're following that procedure. Usually it goes through the sheriff's merit board and things like that. But nevertheless, we have to be careful. Yes, ma'am.
Another question.
Sure.
In our policy book, we say that they have to have one verbal warning, two written warnings before they can be dismissed.
Mm-hmm.
But then we have elected officials that say this is an at-will state and we're going straight to dismissal. Can you do that?
Well, I wouldn't do it. I mean, again, I'm not trying to give you legal advice, but I wouldn't do it. I don't know if you really look at it as being at will anymore, because they could, in many cases, what happens in those cases is they come back and they say, well, I had a disability, or I had, you fired me because of my sex, race, religion, national origin, some discriminatory intent involved. So that's when it falls back to, if you have a system that you're stepping up, okay, you have first warning, second warning, those are fine, but just make sure you're documenting the reason why you're terminating the individual. It can't be for discriminatory intent, so you need to be able to show that. Okay, everybody in the office might know the reason why, that they're not showing up to work on time and things like that, but do we have that documented properly to be able to demonstrate that? I'll talk about annual reviews, but if you're doing an annual review on somebody, make sure that you're telling the truth or not sugarcoating whether or not that employee's doing a good, bad job, because if you're saying they're doing a great job and they're really not, and then we have a termination, well, they're just the first thing they're going to pull up as Exhibit A in a lawsuit is that you said I was doing a great job when they really were.
Well, we actually had someone who got a excellent evaluation in January and then was fired in March. Yes.
Yeah. So again, Exhibit A is going to be the fact that you gave they were given a very good evaluation. Scale of 1 to 5, they got 5s all the way through. They were excellent. So that's something you need to avoid. So just be careful of a lot of times you put the at-will doctrine in your handbooks and things like that to make sure you're warning people that they are at will and they don't have a right to their employment. You don't want to put anything in the handbook unless you specifically are doing it on purpose to make sure that these people know that they're not they're at will and can be terminated without cause. Probationary periods. Just want to briefly talk about that. Probation periods are not really recommended. And the reason I say that is because the fact that if these people say for example in your handbook say you complete the 90 days of probationary period for your employment, so people get the idea that once they reach that probationary period, they have a right to their employment. And there's been a lot of lawsuits brought where people try to show that once I completed my probationary period successfully, now I have a right to continued employment. Well, again, that's what we call an at-will killer. So you want to be very careful about that. What we actually recommend is you add a provision in your handbook that successful completion of the orientation period does not alter the employee's at-will status, and the employee does not receive a right to continued employment, and the employment may be still terminated at any time or without cause. So that's just a recommendation. You might want to think about putting that in your handbook. I'm not saying you can't do probationary periods, but they can be problematic. So you need to kind of consider that and whether or not that's really something you want to have in your handbook. So again, just something to think about. I've already touched on job performance evaluations. Again, make sure you do those. There's no problem with doing them. Okay, you need to evaluate your employees, but I think the goal is if we have a problem employee, we want to make them better. So the idea is that be truthful about it. Try to help the employee. Set some goals for the employee to make to see if they can do a satisfactory job of performing their job, and if they can't, then at some point you may have to terminate them. So if it comes down to termination, we want to be very careful that we've got that well documented, and we didn't say that again they were the best employee that ever came to this county. Because if they're not, then we need to help. You're not doing them a favor, and you're putting yourself potentially in some legal jeopardy. So just be careful about these annual reviews. Again, we talked about the fact that the counties are a governmental entity, so again, we can violate constitutional rights. Now, one area that I seem to run across quite frequently is that we have county, cities, or towns that are doing random drug testing across the board with everybody, and I'm talking about clerical individuals, people that are what we call are not safety sensitive. Now, what you have to understand is that Indiana's in the Seventh Circuit Court of Appeals, so the Seventh Circuit Court of Appeals actually held that the collection of breath, blood, and urine samples is a search covered by the Fourth Amendment. Again, we can violate somebody's constitutional rights. So the search may actually violate an individual's reasonable expectation of privacy. Therefore, testing must be actually based on at least an individualized suspicion or misconduct. Now, a commercial driver's license, a person that holds a commercial driver's license or operates heavy equipment, that's safety sensitive, okay? And there's federal laws that say we have to randomly drug test the person's holding a commercial driver's license. But suspicious random testing is permissible when it serves a special governmental need. So a special need actually exists when the employer holds a safety sensitive position. So that's actually the key word, safety sensitive. Okay, so safety sensitive is defined as a position fraught with risk of injury to others that even monetary lapse of attention could have disastrous consequences. So we need to determine if we're going to do random drug testing, whether or not that person falls in that category. So you just need to be very careful because there could potentially, if they're not, could be a violation of the Fourth Amendment of the Constitution. So we have to be, again, cautious of our random drug testing program because I get questions like that all the time about that. There was actually a Seventh Circuit court case that came out of, it was actually came out of the city of Marion. It's called Craig versus Siebold. But anyway, I can give you the citation on that if your attorney wants to look that up. But anyway, very important from the standpoint of not violating somebody's constitutional rights. One thing we talk about a lot is discrimination and harassment in the workplace. Harassment is just really permitting a work environment that is hostile to an employee based on their race, sex, national origin, or their religion. So again, I think from a risk management perspective, what we want to make sure that we're doing is it's a matter of education. Make sure that your supervisors, your foreman, anybody that's supervising an individual understands that it's not permissible to harass somebody or allow their co-workers to harass other workers based upon these protected traits because of the fact that there can be a violation of Title VII of the Civil Rights Act or some other employment-related law. So any kind of offensive conduct, this is what the EEOC actually says, the offensive conduct is so severe or pervasive that it changes the terms and conditions of employment both objectively and from the individual's point of view. So a reasonable person, would look at it and they say that's harassment in the workplace. Now the law actually doesn't say harassment. If you read the laws, they don't ever say harassment. It's actually discrimination. Harassment is just a form of workplace discrimination and is prohibited by not only state law but also from federal law. So the advice we always give our public officials is that the thing about it is that why take a chance? Don't get involved in any type of activities which may be construed as harassment in the workplace. And again, it's not just sex harassment. It can be based on any of those protected classes. So we have to be very careful. And again, we have to make sure that we have an anti-harassment policy and that we also have a complaint system to deal with that. Very important. Again, it falls back to documentation. So if we have a written anti-harassment policy, again, make sure it's followed across the board and that we have a complaint procedure. So if somebody comes to us and complains that they're being harassed in the workplace, we want to undertake a procedure to where we document what happened. We undertake an investigation, and that needs to be done immediately. It doesn't need to sit very long because the sooner we try to intervene and find out whether or not there is harassment and correct that situation, the better off that the county is going to be. Now, supervisors actually have a special duty to set examples for others in this particular areas. So that's why we need to make sure that our supervisory persons who, again, have direct the work of other people in the county, that they are aware of these laws and that they have a special duty to stop that activity if they observe it going on. Because in many cases, they may be actually involved themselves. So we need to make sure that they avoid that, because supervisor misconduct can actually subject your local government to liability. So actually the county is automatically liable if a supervisor takes an adverse action against an employee. Again, the employer is liable. So if core workers actually harass an employee, the employer is liable only if they were aware of the conduct and failed to take reasonable steps. That's why we need to have a system in place in writing to make sure that we're addressing these issues. As far as, if there's harassment in the workplace, again, we have a complaint procedure. We document what the complaint was. We document our investigation and what we did to correct that situation. So again, it's important that we have that grievance complaint procedure available for all of our employees and make sure that they know it's available, because that will help alleviate the liability if they fail to take advantage of a complaints procedure. Now, almost all of these laws have a provision in them that you cannot retaliate against an employee for engaging in any kind of conduct that's protected by a statute, such as filing a complaint of harassment in the workplace. So make sure this is another area you want to make sure that your employees are aware of, that and your employees and your supervisors, is that they want to make sure that they understand that they can't be retaliated against for conduct. Again, if they participate in an investigation, if they file a complaint themselves, your supervisors, your department heads, your elected officials cannot take any kind of retaliatory action against these individuals for doing that. So you just have to make sure that we don't do that. A claimant for retaliation actually exists even if the underlying complaint of discrimination was without merit. So again, even if it was without merit, you still can't retaliate against an individual employee or official. As far as disciplinary action, be consistent with all your employees. I think we're going to talk about that a lot as we talk about documentation. Be very consistent with the way you handle disciplinary action within your department or within the county, because you don't want one person to say, well, that person came in late and you didn't do anything to them, but now you're punishing me. You're writing me up for being late. Well, again, we have to make sure that we're treating everybody the same. So you have to look at all employees the same. Not just, don't use any favoritism towards any specific employees. Disciplinary action taken concerning an employee should be carefully documented. Again, talk about that again. Very important that we document this stuff. Write it down. If you don't write it down, it doesn't exist. And if you go into, again, I'm not a lawyer, but if we go into a court setting, if we don't have good documentation, it's going to be very difficult for the defense. And I say defense lawyers because we're defending the county against liability. It's very difficult for them to prove that we did, in fact, not discriminate, for example, against this employee if we don't have the proper documentation. So again, this provides a paper trail in the event of litigation. So one thing, again, I'll just reiterate, document. Very, very important from the standpoint of risk management in managing this litigation when it does happen. Most of the litigation that we see in the insurance industry is based upon employee termination. So once we terminate an individual, again, we got to make sure that we're properly documenting the reasons that we're doing it. Okay. Again, we go back to the at-will doctrine. Their at-will can be they don't have to be terminated without cause. So you want to make sure that you have good documentation in reference to the reasons why you're terminating an individual, so they make sure that they're not discriminatory or retaliatory in any way. So again, it falls back to documentation. Make sure that you're able to clearly demonstrate why this person is being terminated through documentation, and then also get legal counsel or HR involved on the front end. One thing we run into a lot of problems with is we have an official who goes out and terminates an employee, and he or she doesn't consult with the county attorney or some type of legal counsel or the HR if you have that. And then we find out that there's no documentation. He didn't have his ducks in a row. The employee turns around and files a lawsuit or goes to the EEOC, files a complaint, ends up going into a private lawsuit, and then we're in big trouble because we don't have any documentation to support that termination. So, just another area where we can run into problems. You're probably familiar with the Equal Employment Opportunity Commission. If somebody wants to bring a claim that's or a suit or a claim that's enforced under the EEOC, they have to file a charge within 300 days. Okay, And then what you're going to do is you're going to get either some paperwork, and I think they're going to start doing it. Ken, are they going to start doing that electronically now, I think? But anyway, you're going to have electronic response that you're going to have to make back to the EOC. In other words, your response to that charge. Now, one thing I just want to recommend is that that's done by legal counsel. Don't write it yourself, because unless you're very well versed in the law or you're an attorney, I would not do that, because what you put in that response to the EOC may come back to haunt us later in defense of a further private lawsuit, which may come later. In other words, the EOC has to approve the individual they have to give them the okay to bring a private lawsuit. So once they do that, then we've got to defend it. And again, if we don't, if we made an improper response or there's something in there, some smart attorney is going to pick up on, then we might have a problem. In Indiana, we also have the Indiana Civil Rights Commission. In this particular form, an employee can file a complaint with the ICRC within 180 days of the alleged discrimination. And all these responses should be done, again, back to them, the same as the EOC, by legal counsel. She might, again, get some kind of notification from the Indiana Civil Rights Commission also. So just as a word of advice, please make sure that your legal counsel responds back to that. A lot of times, your insurance provider can give you an assistance. We actually will provide legal counsel to assist in the response to those EOC charges. So just make sure that, again, somebody that's a legal attorney or at least an HR person makes the response. Sometimes we get requests for references. I get this question a lot. We get a request for references of former employees. Typically, what we recommend is that local government officials actually encourage to provide neutral reference information to employers who are seeking a reference on any current or past employee. What we typically recommend is to provide only the date of service, positions held, and salaries paid, except as otherwise required by state law, including the access to public records law. So that's just a general piece of advice that we give. However, in Indiana, they amended the Indiana blacklisting law just in the last few years, and they've actually amended this statute. What it does, it provides the employers with immunity from any civil liability if they disclose information about a current or former employee. Now, it has to be truthful information. So if the county distributes false information, they still can be liable. But according to the IC 2253, the Indiana blacklisting law, they are now providing, it was amended and is now applying civil immunity for giving out that information. So again, I think what I'm saying is that you have to make your own decision on what you're going to do, whether or not you just decide to be very neutral about it, or if you decide to disclose the information, just make sure that you talk to your legal counsel about how you want to do that, because you want to make sure you put yourself in a position to be immune from any liability if, in fact, some type of litigation results from it. And always get any kind of a signed authorization release from the former employee to release that information. So, again, just some helpful hints, some things to think about when we're out there doing that. Electronically stored information, again, everything's a matter of public record. It can be typically in a lawsuit. All this information is usually given out. You have to make sure we preserve all this information. So make sure that we have emails back and forth, memos, what we call to-froms. Make sure we're keeping all those, and just remember that any of the information, emails, memorandums, policies, anything like that you have may be construed or may be overviewed by a judge, jury, and that type of thing. So we want to make sure that we write those properly. They're not discriminatory in any way. So we want to make sure that we're very careful with what we're doing. Be very professional in the way we're sending out emails, what we're putting in the content of those emails and things like that, because your words can be misconstrued. So be very careful how you word emails. Also, very importantly, make sure that your employees and people within your offices or within the county understand what the policies are in reference to the use of electronic devices as far as sending and receiving emails and things of that nature, because those can be very problematic if they're used improperly. In other words, don't be sending out inappropriate jokes over, via email or anything else. be very careful. It's my understanding, too, that even if you're sending them on a personal device and if it involves the county business, it still can be a matter of public record. So just have to be real careful about that. Need to make sure you're setting some parameters on what the prohibitions are. Make sure that your people are properly trained on it. Electronic equipment is again the property of your county and should be used only for lawful and appropriate business purposes. So that might be something you might want to put in your policy. Employees cannot send any kind of harassing or discriminatory emails. Again, it all falls back to a good control over what you're going to be allowing to happen with your email system as far as inappropriate use of it. So again, we have to have a policy on it, make sure that we're enforcing that and enforcing it even-handedly. Warn employees about any prohibitions, parameters, and get a signed acknowledgement form that they understand what the policy says. So if they do violate it, again, there can be disciplinary action. So just another area of potential concern that you might want to think about. Okay, so we'll finish up by talking about how we're going to minimize risk. We talk about identifying, what we do as risk managers is we go out and we try to identify different types of exposures which might bring a lawsuit, might expose the county to potential liability, might expose an individual, official, or an employee to potential liability. So we want to make sure that we're minimizing these risks as much as possible. So ask yourself, could I explain to a judge why this action is based on, not based on politics, speech, sex, race, etc.? So you need to ask yourself, okay, so if you can say, it doesn't, then you're in good shape. Do not even joke about sex, race, religion, etc., even if the jokes are welcome. In other words, a key element in whether or not it's harassment in the workplace or discrimination is whether or not it's welcome or not by the other party. So, but I want to refer back to what I talked about earlier. Don't take that chance. Don't allow your employees or yourself to get involved in any activities that might be construed as discriminatory in nature. Again, anything to do with sex, race, religion, any of that stuff, you need to stay away from. Again, I already talked about this, but supervisors do have a special duty to set an example for others and other supervisors. And misconduct can be subject the city, town, or the county to potential liability because, again, if a supervisor takes an adverse action against an employee, we're pretty much, it's automatic liability. So we need to make sure that, our supervisors on up, plus our employees, are educated in these particular areas. So we try to avoid that type of misconduct, which will lead to these types of claims. Prepare yourself for the hiring process. Again, we talked about that. Good. Make sure you're reviewing your applications. People who are interviewing applicants, make sure they ask the appropriate questions. Make sure that's documented. Don't terminate an individual without a legal review. I think we can pretty much throw the at-will doctrine out the window and consider everybody, that they have some right to their employment, because at some point they're going to claim that they have some right to their employment based upon a protected class or some other issue. Get up to date on employment laws and update your personal handbook, your HR procedures. I don't have a lot of counties that have HR directors. They're very fortunate if they do. I know a lot of times it's fallen to the auditor's office, and I know that that's a real burden on you, but it is a very important thing to profession. It is a very important office, and it is very important that we, again, follow these different guidelines to make sure we're avoiding these adverse situations. Follow all your written policies. Respond to employee complaints promptly. Again, I want to emphasize that. Do not retaliate against anybody for taking an employment action. And then finally, as I talked about, just make sure that you're carefully documenting all your activities. And that'll go a long way towards helping your insurance provider or your legal counsel in successfully defending these cases. But in many cases, we can get it dismissed quickly, and we don't even have to get into a long, drawn-out court proceeding, which costs a lot of money, a lot of expense, and a lot of headaches for a lot of people. So really that's what we're trying to avoid. So just be careful out there. Make sure you're documenting. Again, good written policies. Those are the things, training, those are the things that go a long way towards alleviating potential liability. So anyway, does anybody have any questions? I know we kind of covered a little territory there because we were trying to get done in our time frame there. But if you don't have any questions, I'll leave some of my cards. If you have questions, concerns. I'm sorry, do you have a question?
The only thing that I wanted to tell I used to work in the auditor's office. I was combined HR and payroll. Our new auditor came in policies that need to be in your handbooks. It is endless for HR. So I know that working in that position when it's combined with payroll, there's not a whole lot of time, but this is something that gives you an opportunity to have a tool to work with. So if you get a chance, check it out. You do have to buy it, but we were lucky, our insurance providers, our insurance, we pitched in with them and we bought it as a group. So you can do that, maybe if you find some counties that need it.
Yeah, you might want to check with your insurance providers. We actually, clients of ours, we have a program actually called Practical HR Resources. It's an online service very similar to what you just spoke of, and we can provide that to you. But I would advise you to try to work with your insurance carrier, because sometimes they may have resources you can tap into that don't cost anything, because the services that we provide actually come along with the insurance contract. So we would provide those services and the reviews of the employment manuals, training of employees and supervisors, those types of things. They can do that with no cost to you, hopefully. So, all right. Thank you.